So first, I just want to welcome everyone here on behalf of SciPart. It's excellent to have everyone. Can everyone hear me all right? Yeah, good. It's excellent to have everyone here, and would like to thank the Masters Conference and Kat as well for putting together an excellent event. So we've heard a lot, and I've been attending a tremendous amount of conferences lately, as I'm sure that many of you have. And one of the things that is consistent across all of them is this inevitable march forward with regard to AI, right? It's almost we're rushing towards it, and there's this feeling, this need that we've got to do more, and we've got to stay on top of it. And gosh, we had better be innovative, users of AI technology. And so, I'm often faced I went to an HR AI conference, and as a lawyer, the whole conference for 3 days was all about the use of AI in HR practices. And as a lawyer, people are up there saying, well, we're just going to put this here, and we'll put this into AI, and do this and do that. And I'm kind of quietly having a panic attack. We have a unique challenge right now, right, in this information governance space to not slow down, the progress here, but at the same time be responsible with respect to the implementation and the use of AI. And so is our hope for this panel, and this is an opportunity for you all to ask questions, right? What does it actually mean? How do we address the legal risks that are inherent in the use of this technology? Where is the regulation going, right? How are different areas being regulated? What are we seeing in the EU? What are we seeing in the States? What does it mean, in litigation? A lot of us come from e-discovery backgrounds, privacy backgrounds, cybersecurity backgrounds, and this is a natural fit for us because all of these disciplines overlap, right? So we're going to talk about some of these risks today, and I hope that you will ask questions. We've got Yana Kaminsky, who is part of our international data law practice, privacy professional, and Jason Prevey, who is also a member of our data law practice and associate general counsel of our firm. He's our chief privacy officer. So he's wrestling with these issues in terms of our implementation of AI as well. So I have to give this disclaimer. This is not, don't construe anything here as legal advice, but this is a unique opportunity, I think, to ask questions that potentially might be in the weeds, right? What does it mean? What do these regulations mean? What's human in the loop mean? What is it when we have oversight or we have to do bias testing? What does that mean in practical sense? As I mentioned, the issues and the risks of AI are an overlap of a variety of different disciplines, right? So there's e-discovery issues, litigation risk, privacy. A lot of the frameworks in privacy kind of apply here as well. Cybersecurity, and of course, information governance. There's a lot of overlap. So we thought that we would kind of set the stage by kind of framing out, what is the actual regulatory framework that is, being developed right now? What does the patchwork look like? And from a practical perspective, what does that mean, for businesses that are trying to implement these tools? So for this, I'm going to turn it over to Jason and Yana just to kind of give an overview of the current regulatory framework.
So I'm going to start with domestic U.S. side, and Yana can speak to Europe, I think. But generally speaking, my common theme, I think, for talking about regulation is that it's really mismatched across the real risks that we're going to be talking about later and some of the real concerns that are out there. And the reality for businesses that are rolling out AI technologies is that stuff that was illegal before is still illegal now. You can't discriminate against people. You can't, be biased in your hiring or your promotional practices. And the thing to be on the lookout for, though, is unintentional consequences of using AI models, or maybe sometimes even misusing AI models, where the results could get you in trouble with that. And the state regulations, generally in the U.S., we're talking about California and Colorado right now. but they're directed towards use cases. So things that you do. So the term for automated decision-making technology that has it is consequential decision-making. So what does that mean? So well, it's anything that actually could affect someone's individual rights. So does this person get an apartment? Do they qualify for a loan? Are they going to get some kind of other preference or something else? And certainly in the HR context, we're seeing direct regulation about that because there's a lot of concern about the robot deciding whether someone's qualified or not for a job, or whether they get a promotion or anything else. What's the interesting wrinkle or spanner that got thrown in the works, as some might say, was a few months ago was an order from the White House. We had an executive order that supposedly put a hiatus on all state regulation that was of AI because it was stifling our country's innovation in these tech companies. But even that's kind of has some squishy language because it's directed towards state regulations that provide that give some sort of a burden to AI technology. Well, if I pass a law that requires a notice to people that I'm using AI, is that a significant burden on the business? Probably not. Maybe not. It's definitely arguable. There are some things coming that are a lot more burdensome. And again, really, where things are really drilling in is any use of artificial intelligence or automated decision making in the employment and workspace context. So, and we're even seeing that now with regulations interpreting like employment laws in states like Illinois right here. And what's currently we have is sort of a high-level law that's doesn't look too bad. It just says you can't discriminate, and everybody's like, yeah, well, of course we weren't discriminating before. That's fine. But then the implementation of the regulation that is at least currently in draft form requires notice, opt-out, multiple publication of the notice, and lots of other requirements that arguably would be a burden on businesses to do. There's also something in New York City, but not New York State, and there's a lot of other draft regulations there. Again, directed towards really focusing on HR use, but other kind of issues and concerns that aren't directly being regulated, like price fixing, like collaboration, antitrust violations. Some of these other things we're going to talk about aren't really touched by these specific laws, but they should be on everybody's radar screen. So on to Europe and AI directive.
Yeah, so just looking around the room, how many of you are concerned about deploying AI outside of the US? Okay, Jason's very concerned. All right. Yeah, so I think we look at the EU AI Act as leading the way. We should be cognizant of the fact that these are global issues, and even there's several other countries with frameworks coming online, and even the ones that had decided for now not to create a specific AI law, what they're doing is really restating some of the things that Jason has said in guideline form, saying, hey, look, Australia is a big one that I think of a lot. Hey, look, this technology is going to impact and implicate all the existing laws we have, and here's how. And so that's something to think about as you deploy, not just in the HR space. And Europe, honestly, is leading the way in kind of being a technology agnostic, but also use case agnostic, in saying it's really up to developers and deployers to think about what the technology does, to really understand it a lot better, and to not focus on notice and consent and kind of explaining to the user at a very high level what's happening, or to the data subject. We're really talking about new obligations that require you to get to know your product or the product that you're implementing at a whole new level that privacy law before did not anticipate. And we're not only focused on data anymore, we're now focused on the tech itself, even if it doesn't touch data. And when I say data, I mean personal data or PII. So really much more burdensome. The goal in Europe was not to do that. The goal in Europe was to pave the way for competition in technology and to become a more competitive space for European developers. Whereas California has mimicked some of the European principles-led framework with its risk assessment requirement, and possibly has not done it in a way that makes it very user-friendly or commerce-friendly. So there was a lot of activity and pushback from commerce in California, arguably less than in the EU, because in the EU they look at this as like a bit more like you are helping us compete and be across the board as a single market. Whereas in California, business looks at legislation like this as a burden. So I think what's important for us now is to think about, okay, with everything in the States is arguably in flux, everything in Europe has long deadlines, has some grandfathering where we may be able to get away with not doing anything. And really that's a tendency for US companies to look for ways to kind of check the box and move on. And this legislation is really forcing you to not do that. It's really saying, no, you're going to have to know your tool. You're going to have to know what your tool is doing, how it's impacting. And things like risk assessments, which we've done under GDPR, we've done for other purposes. Now we're really looking at much more complex risk assessments. And even though this legislation set in California and in the EU says you can use existing processes and standards that you have in place in your organization, the work required is much deeper. So I urge clients now to go ahead and get started on that work. I have clients who say, I don't think we're using any AI in our entire HR stack. And that's because they've been using the same tools that they used 10 years ago, but the tools have changed, brands, right? But the brands have changed, and they're launching AI components that not everyone in your organization is aware are AI components. So really, really time to get knowledgeable about everything you do and set a process in place to make sure that you are aware when a tool kicks in and what it's doing.
And 2027 will be the year of risk assessments, and there's more to come for that too. But again, regulations are great, but let's talk about lawsuits, right? So lawsuits are coming regardless of what a state regulation has, and certainly what we've seen with lawsuits over purported addiction to chats and other things. And there's even state regulation in California of chatbots, although there's exceptions for like gaming and customer service. But that's also coming, along with even potential creative claims for consumer fraud if someone's interacting with an AI and you don't tell them. So more to come there, I suppose.
Yeah. So, any questions from the audience first before I move on?
So regarding some of the restrictions, in particular with art, how are you defining the large umbrella that AI is? Because AI encompasses not just Gen AI, it encompasses machine learning, it encompasses formula creation. How is the GDPR delineating between that? Because you've got things like with art, if I use Photoshop and I generate a sphere in Photoshop and save it and go, look, I created art. Well, I didn't really. I used an algorithm that created that sphere, which is technically AI. Is that now labeled as AI art?
So in the European framework, the intention was to be really broad. And unlike in California, where we say ADMT or automated decision making, is really more regulated if you're making a significant decision about an individual. Otherwise, it's kind of almost not as regulated. The EU AI Act and the progeny that comes before it of all the harmonization legislation is really not looking to make a lot of carve-outs. So what they talk about this in terms of categorizing technology. So everything that is AI, and then there's high-risk AI, then there's a little bit lower-risk AI, and then there's kind of okay AI, and then there's something that's, there's certain types that are totally prohibited as considered to be just too scary for now. And the definition is fluid to allow for the technology to develop, because they did recognize in the legislative thought process and philosophy that we are going to have technology that looks totally different a year from now, let alone 10 years from now. And the legislative process is so slow over there because of the way the union is set up. They really need to get it right and be broad enough. But you raise a good point. We do need to look at the threshold matter is really what jurisdictions are relevant to us and what is the definition of AI in the jurisdiction that's relevant to us. And yes, we need to come up with, for those of us who are global or multinational, we need to come up with frameworks that work in California, where there are all these exceptions, in Colorado, in South Korea, in Saudi, in the EU. Sorry to not really answer the question directly.
At least I got in the general area.
I mean, that's the tricky part, right? And that's, I guess, one of the things that makes me nervous a lot. Everyone should have some degree of imposter syndrome right now as we try to figure this all out. But for an organization that's functioning on a global scale, it is a significant challenge to really understand, the regulatory frameworks and the risks that are going to face you, and then to build a governance structure on top of that for a legal organization within a business that is, an F1 car. Max Verstappen trying to get that, trying to get the win. So it is, it's challenging, and I don't think, the answers that we give today may not be the same answers that we give 6 months down the line. But I have to agree with Jason that 2027 is definitely going to be the year of risk assessments, and we're going to start to see some of those litigations taking place. And we're not even certain exactly. We can't say right now what all the risks might be.
Well, I mean, there's a few and that aren't touched by the regulation. We're short on time, so I want to make sure I hit these. We've got plenty of companies out there that are doing a great job monitoring and even doing leaderboards for who is using AI the most, because they want to get the most bang for their buck, and they went out and bought these tools. And maybe they're even recording prompts and results and keeping them indefinitely. But there's risk in terms of what's going into these engines, and also there's risk in terms of where those are. Are they captive? Are they consumer grade? Are they on people's phones? And then also what's coming back. So in terms of what's going in, you're talking about potential risks to confidentiality, proprietary information, trade secrets, and which I think maybe where you're going to is it's like ownership, and if I put in a logo from Coca-Cola and want it to make meal, or something else from a competitor and want it to reverse engineer something, it could be a real problem potentially. And if those things are happening of a business is doing that, and then it's taking whatever the result is and trying to use it commercially. Not to mention legal privilege and concerns about legal holds. I mean, if we have a litigation hold, I mean, we're starting to see discovery requests for if you have AI prompts and results associated with this or that. How do you harness that? How do you control all that? And I mean, it comes down to internal controls and training, of course, and policy, but that's not going to be perfect because people are going to find ways, and so we constantly have to get smarter and smarter. And the other risk, just to hit on really quickly, another part of my day job would be the massive cybersecurity risk we're seeing. I mean, people probably heard about all the news about Anthropic's Mythos and Project Glasswing, but hackers they don't need this latest Mythos to start using AI to try and compromise and hack companies. They're using it now, and what they're doing now maybe is 90% automated and 10% human controlled. And what's coming is just simply 100% automated. It's a scary time to be involved in data security, and there's a constant arms race going on with that too. And all of these open ports and open windows that you have as you're really banging the drum, getting people to use AI as much as possible, we just need to keep control over that. And lawyers are often the ones throwing cold water on the fire here, especially when people want to move fast and break things, so to speak. But there's a lot of real risk and danger here to an organization.
Thank you, Jason. Any questions from anyone? Yes.
What are you actually doing about the core mythos? Because, I mean, obviously the big eight, they've got time to prepare, but what about like everyone else in the world?
Good question. So, and it's interesting. I mean, I don't know much about it other than the fact that OpenAI says they're releasing some kind of a cyber model, which might be mythos for the people. I don't know. I think, and there's also Anthropic's supposed to be releasing a new edition of Claude, Opus, like maybe tomorrow, which maybe it's not going to be mythos. And there are also people who are cynical about the whole thing and saying, well, isn't it interesting? They're about to have an IPO and suddenly they make this announcement. So I think that I believe it because I've read the documentation article, so I think it's a real deal. I think the answer will be, as I mentioned, this arms race of some kind of technology to basically come through and expose things. The problem is software developers have been lazy and they put things in. I mean, Mythos was finding vulnerabilities that had been in existence for like 17 years, 20 years that somebody should have found. But I think the solution is really technology for companies like Jetstream AI, relatively new but very impressive company that is really on the frontier, the leading edge of doing some of this preventative, technology of fighting fire with fire, so to speak. And I think that's the only answer because we're not smart enough in, I'm not even going to talk about quantum computing, which Google just moved up the schedule to 2029 for Q-Day. So that's when all the internet encryption will be broken by commercially available quantum computing.
No, in the interest of time, I think if anyone else has specific questions on that, let's keep talking about that. I think you use the word lazy, and I feel like that's really the where we're headed as a civilization, is we're constantly fighting our laziness and trying to enable it, including with things we're doing here today, and that's human and normal, and and I think we should, because we all want to be doing things that aren't in suits. But what we need to do about that is to implement process to make sure that we're smart and careful and methodical about how we buy into tools to enable our laziness.
So we do have a somewhat condensed time frame for this. Oh, go ahead.
I was going to say on the laziness part, the hallucination cases are lazy lawyers.
Yeah.
Basically, I had to go to Stacks and pull the books off the shelves. We weren't allowed to use Keysight and Shepard's on the computer back in the day.
Yeah.
So if you can't even do that, that's super laziness.
I'm always astounded by the number of cases. What was the number?
It's over 19, or no, was it 1395, I think.
There's a neat website that tracks them.
Tracker.
Yeah,
Yesterday,
it's
yeah.
really
So.
pretty neat.
But anyways, so Jason and Yana already touched on some of the other risks that we wanted to talk about more in depth, but obviously the e-discovery and the litigation, the AI as evidence, right, is a thing, and we need to be thinking about that and thinking about our existing frameworks for governance for litigation and e-discovery and legal holds and records retention, right, and really what that means. It was important before, it's even more important now, but it's not really that exciting. People don't give it a lot of attention necessarily, especially when there's this flashy F1 car, going down the street. So but it is really, really important. And so I wanted to skip over some of that in-depth discussion to make sure that we talk about governance. Personally, even from my perspective, this is, trying to figure out a governance framework that works for a global organization that has these issues trying to implement AI, along with cybersecurity and privacy risk is challenging. I find it stressful, oftentimes. But I wanted to talk to Jason and Yana, and perhaps for them to kind of explain a little bit how they would tackle something like that. What are the things you really need to think about, how you would go about it, and then some practical takeaways.
Well, we just published a blog post on utilizing existing frameworks and building this on top of that, and the opportunities there to be lazy, but also opportunities or pitfalls of being too lazy. And again, as circling back to what I said earlier, there's just a lot more in-depth work and understanding that needs to happen, and I think putting out fires is hugely inefficient. Everybody says, we go to these conferences, the HR conference was really an eye-opener for me because there are like a bazillion vendors and they're all pushing things and they're all saying, oh, we're fully AI compliant, we're fully privacy compliant, we're fully this. And you can't really tell who's just totally making it up. It's like a sea of potential scary pitfalls, but also a lot of opportunity. The products are amazing. So rather than do it backwards, I guess start from whatever your existing framework is. Think about where are there interaction points where you can integrate assessment of each tool, assessment of what you're going to be allowing people to do and what you're not, and then go through the motions that are quite tedious of analyzing, well, what definition are we working with in which locations, and what do we need to do in each location. And I think we're really getting to a place where we cannot continue to do things that globally, like we were kind of not in that place with privacy, but we were doing it, and we have global disclosures, global policies. It's really getting to somewhere where we need to look at a bit more of a granular level when building the framework. That's what I urge clients to do in a way that is not going to be overly burdensome, and not to wait till next year, but really start now, because the work is so much more involved and involving so many more stakeholders in your organization than ever before.
Take stock, though, of what you're doing. What are your people using? Watch out for shadow AI. Make sure that you control things. You can't just do that with a policy and a 10-minute video training for your people on how to prompt. I mean, no disrespect to the last panel, I just remembered that. But it's there's a lot out there, and your people are doing stuff that you don't even imagine they're doing, and it's something. Yes, you can have policy and training on it, but you do need to do something, some kind of technology view or audit or search, or to look on your network to see what's out there, to search and destroy those where they are.
I mean, the people themselves don't realize what they're doing.
Yeah.
They don't, in the sense that they don't know that there's AI involved in every situation where they're using it.
Even something as basic as saying you have approved Copilot that's in a captive version. Sometimes your personnel will be like, well, I've got Copilot at home. I've got Copilot on my phone. Isn't that the same? Well, no, it's not the same, but to make sure they understand that. And if there's something you can do to maybe put your brand or put on the website through a portal that has your name on it so they know they're in the safe zone, that's good to do.
And having Copilot enabled is one thing, enterprise-wise, but then where you're putting it and how you're connecting it to other things is a whole other thing. And letting people, yes, you can let people use it in a multitude of different ways, combining with other tools, but how does that change? How does the use case change? What you've previously told people you can use it Copilot for, do you have to update that? What mechanism is in place to keep track of those things happening?
Copilot, show me the CEO's performance evaluation. Copilot, give me the root admin password. So these are things that ought to be safeguarded, but you should test. Make sure they don't, that you have the controls in place.
Questions from the audience, anybody?
Do you have any concerns, or issues about using a DCR in regards to privacy data?
Define corporate rules.
DCR, data clean room. And being
Oh.
able to merge between two sets of privacy data in a vacuum and getting output results of the attributes that are non-PCI or PII data and being able to share those across those two parties.
Are they in different countries?
They could be.
Oh, it's complicated.
I think that's a complicated question for the last 2 minutes in this presentation. You have to make sure you're following a process. So I think we need to talk offline on, but happy to do that.
Yeah. And there's a lot of questions too about data sovereignty, anonymization of data, repurposing data, customer pricing information. There's just a whole wealth of issues with respect to AI ownership, and even down to that, if you're doing vibe coding, do you own it? If you're creating that sphere, but heck, what if I'm creating a whole operating system with AI? At what point is it mine? So they're just, as Jay mentioned, there's stuff we haven't even encountered yet, but there's plenty are coming up.
What we're encountering right now is where there's doubt about mixing data from different jurisdictions and what rules to apply. People are carving out at the moment the scary jurisdictions. And that goes for tools as well. Like, we will not use the tool in the EU, which could be backwards thinking given some of the actual law that says, if you're using it now, you're okay. But that's just something you need to consider as you implement.
Well, we want to thank you very much. We'll take one more. Good, so we're keeping you from lunch, basically. And so we want to, but we'll take, go ahead.
Since Q&A was brought up,
Yeah.
and it's fair game now, what's going to happen with jurisdictional issues in a quantum environment? Because superpositioning, the GDPR makes 0 sense.
So, like I said, we don't, at the very beginning, we said, it might look completely different, 6 months from now.
Yes.
So that's my answer to that question. So I just want to thank everyone again. It's important to recognize, while these things are not necessarily fun to think about, there's people thinking about them, and it's important to think about it. So thank you all very much, and hope you enjoyed lunch.
Awesome. Thank you guys.